Do I have legal grounds for retroactive compensation claim if the work I have been doing is more and differs from the job title on my employment contract? It depends, maybe. So it depends on a few things. One, if you clearly objected to conducting this work, and so registered your grievance and to the employer. So then you can potentially then file a case against the employer for breaching their side of the agreement, providing you with the work that's in line with your employment contract. But you need to remember that there's a statute of limitation for employment cases. Now it's 2 years, but until recently it was only 1 year. Now it's 2 years, so you can't go back more than 2 years. So that's that's procedural nuance that you need to keep in mind. But perhaps a more substantive argument or point to keep in mind is that if it depends on how long you were working doing this work that was different from what's in the contract and more of what you potentially were expecting to do as outlined in the contract. And that's because if you have worked for, let's say, 2 or 3 years, and then it can be deemed by the court that you have agreed to the amendment of the contract by virtue of doing this work and for so long, then you've amended, you agreed to the amendment of the scope of work and your role at the company. So that is, that's an arguable contractual theory that the contract has been amended by virtue of your actions, by virtue of your behavior. This is why, so the length of you working for the company would matter. So the longer you worked in this position, the harder it will be for you to argue that the company had done something wrong or that the company had breached the contract. Because ultimately, if this was an important issue and you deem that the company breached the contract, you should not have worked in this capacity for very long. But this is also where the circumstances of your communication or the nature of the communication with the employer also matters, because if you've consistently or regularly challenged the company's assignment and your expectations of you and documented that this is contrary to your employment contract, then to an extent you can argue that this was against your will and the company has breached. But even if you argued this, it still continued to work year after year after year, and then that kind of argument goes away. So in short, it really kind of depends, and also depends on what it is, how much more work you were doing, or how different the work it was. It's possible, but really very much depends on your particular circumstances.